Hello, and welcome to another episode of Williams Mullen's Benefits Companion. On this podcast, we provide updates and insights on employee benefits laws, regulations, and trends. I'm your host, Brydon DeWitt, and today I'm joined by special guest Nichole Labott, Managing Director at SageView Advisory Group. Welcome back to the Benefits Companion, Nichole.
Thanks, Brydon, for having me.
Nichole, over the last several years, there's been a lot of consolidation and changes in the 401k and retirement plan space with record keepers. And I was hoping you kind of give us some insights on what plan sponsors need to be thinking about and what the trends are in the record keeping industry.
Yeah, I think a lot of plan sponsors, and even ones that have been in the benefits world for a while, have been surprised to see all the consolidation that you mentioned, Brydon. Going back 20 years to 2004, there were actually 80 different record keepers in our industry. And that's hard to believe. It's hard for me to remember there were 80 either.
But I agree.
But today there's actually 33. And if you look at that spread of record keepers, obviously some of those have niches. Some work presumably and almost exclusively in the not-for-profit world. Some exclusively work with small plans or ultra-large plans. So in either case, even though 33 sounds like a lot, that's not as much when you start to filter down ones that might be applicable to your retirement program. And if you take one step further, of those 33, there's only 11 of those 33 that record keep more than 1 million participants. So those 11 are the ones that I would identify as truly being committed to the record keeping industry.
Right. So really, as a plan sponsor and fiduciary, you've gone from 80 possibilities to probably 11, right? I mean, it's a huge shift over the last 10 years.
Huge shift. And, if you, again, peel back from those 11 ones that have a specific investment in certain spaces, it's usually a lot smaller number. And I would say, too, that I can remember, even 5 years ago, it would be common that a plan sponsor would be interested in looking at 5 to 7 different firms. Whereas with this consolidation, we're most often looking at 3 to 5 firms at most.
Right. And I always recommend to clients that first they have a benefits committee that's reviewing and monitoring their service providers, including record keepers. But they also, on at least a very periodic basis, go out, do RFPs, and look at the services and fees of other record keepers to make sure that they aren't missing services that they didn't know they should be receiving, and also, most importantly, to make sure they're getting value for the fees, in particular if the fees are being paid from plan assets. But in this era of consolidation, those changes are being forced upon employers. So maybe you had record keeper A who is then purchased or merges with record keeper B, and now you have a different service provider, a different platform, without even going through a fiduciary process. So what's at stake for participants and plan sponsors and for their retirement outcomes as these changes occur and as the options for record keeping services keep dwindling to fewer and fewer numbers?
Well, I think you hit on one particular pain point with all this consolidation. I think a lot of folks in our industry worry that, the record keeping function has become a bit more commoditized. And I think that your point about plan sponsors coming to work with a new record keeper, almost by accident because the firm they were working with previously was purchased, has caused some pain points for plan sponsors. It's different ways of doing business. It's different things that are more important. And so sometimes we get asked the question, is it important that as part of a merger, should that be a trigger for the committee to actually do some kind of due diligence? And, our recommendation, and I'd be interested to hear yours, has always been really stick to that timeline that you've always done. So if every 5 years you're looking at a new record keeper, stick to that schedule. Or if it's every 3 years, sometimes the merger or consolidation has brought about positive outcomes. So that's kind of been our advice. But to your point, kind of what's at stake for participants, I think the last number I saw is that about 49% of Americans save in a retirement plan. And so, you've got the other 51% of our population not working long enough to become eligible, or just don't work for an employer that sponsors a retirement plan. But for the ones that do participate in a plan, I think the fiduciary responsibility to make sure those fees are reasonable for the services being provided is paramount, especially because we live in this world where there's so many Americans that have a significant gap between what they have saved and what they should have saved or hope to have saved to become retirement ready. And so every basis point counts. That's what I would say.
Right. And from a fiduciary standpoint, of course, there's been this wave of litigation in the 401k and 403b area, focusing in large part on fees and fees paid by the plan. And, with this consolidation, it's more of a monopoly. As you said, there are only 11 record keepers with more than 1 million participants. There's less competition. And so that could result in some fee inflation. And if your record keeper kind of goes away or is merged into another record keeper, maybe you don't have to do an RFP right away. You could stay on your same schedule, but it's a point in time where fiduciaries need to be aware of any changes to the fee structure or to the services they're receiving, and to at least take a look at that to see if they do, if circumstances warrant accelerating the RFP process because the changes that have happened are so significant. So do you think this is leading to more efficiency in the market? Am I right that this could cause fee inflation, or is there kind of economies of scale here that it's not that much of an impact on participants from a fee and for plan sponsors from the services that the plans are receiving?
Yeah, I think the disparity in fees has become lessened. So I guess what I mean by that is that, 5 years ago when we ran an RFP project for a client, we tended to see more disparity in pricing. I think that the pricing has become more efficient. And by that, I mean, it's not always the case, but I think more commonly the case when we're looking at, purely at the pricing, which obviously I advise you not just look at pricing, even though that's where all the litigation is, to your point, is that the pricing by different record keepers will be very, very similar. So that's good and bad, right? So it gives the committee the confidence that, oh, okay, well, at least we know what the market bears, and it's a pretty narrow differential. And it forces the committee too to put more emphasis on other things that we recommend, and I know you recommend too, that they look at, which is value for that fee. So what services are being provided, what level of consulting are they receiving, client service, the thing that I think should be valued highly in an RFP.
Yeah, and that's a really good point about the value for the service. There's in the case law and the decisions that have emerged through this wave of fiduciary litigation, it's clear that what the courts are telling us is that there's not a fiduciary obligation to pick the lowest cost service provider, the lowest cost record keeper. It's the fiduciaries have to make a decision as to whether the fees being charged are reasonable in light of the services being provided or the quality of the services being provided. So it really is not that you have to pick the lowest cost service provider, but whether the plan is getting value for the fees that's paying. Are the fees reasonable in light of the value that the plan and participants are receiving from those services? So you have to do kind of an apples to apples comparison of the services that you're receiving from record keepers when choosing a record keeper or any other plan service provider whose fees are paid through plan assets. So Nichole, so here we are. We have this consolidation. We know that our clients should be aware of this and doing RFPs on a regular basis. In this new environment, what does a plan fiduciary who's listening to this podcast, what should they be thinking about, and what are any steps that they should be taking in light of these changes?
I think, Brad, that's a great question. I think the most important thing a plan sponsor should know, versus also referring to as a plan committee, is who are the fiduciaries, and do the fiduciaries know they have this personal liability and responsibility for reviewing fees? That would be where I would start. I think most committee members know that and the importance of doing so, but I think too that they need to do it on a routine basis. That's really important. And I think that at a minimum, on an annual basis, the committee should have some kind of working understanding. I think at the least it would be reviewing the fee disclosure notices, but building on that, it would be looking at the value of what the record keeper is providing. So what services are they providing? And I think for a lot of like benefit managers, they assume kind of how the plan is being administered is how another firm would administer that plan. And that's not always the case. So again, I think at the minimum, understanding the fees, understanding the value for those fees. And there's a lot of good tools that advisors like SageView use to ensure that we document that on an annual basis. And there may be years where you feel like, due to consolidation, for example, that you may want to do something like a request for quote, because I think providing that benchmarking information is good, but it's not live data, right? And so actually going to the marketplace and saying, given these variables, what would your fee be? And within our context, we call that a request for quote. It's usually pricing only. The main purpose is due diligence. It's a good way to kind of just really understand the market. Nothing's really truly broken. And then some plan sponsors choose to do what we call an RFI, or request for information. And that's where more information is provided about the service offerings. It's a good way to benchmark fees using live data. There's a high level of documentation for the fiduciary file, which is really important, but not necessarily that change is on the horizon or they're looking to change record keepers. I think that when there's a problem, maybe you have a committee member that's worked somewhere else that had a different experience, a better experience, or maybe you've just never done formal due diligence in the past. It would be important to do full-blown what we call RFP, or request for proposal. That's more formal. It's more custom, where we're sitting down with the client, really understanding what they think works well, what they think could be improved upon. There's detailed areas of focus where we're going to ask specific questions about plan goals and needs. And there's more pointed questions around solutions and addressing those main points. And that in this case, we're really looking to invite different record keepers in to get to know the client formally, at a minimum, an hour and a half presentation. I'm seeing that be more collaborative and less just speaking to the client, which I think is a good thing. But of most importance of any of these scenarios, I think, is documenting it. When you pull people off out of your C-suite, which are likely on your committee, to do this process, if you're not documenting what you've done, either through the report or meeting minutes, et cetera, you're really doing a poor service to that plan sponsor, because this is the thing that's so important from a litigation standpoint.
Exactly. I mean, that's the exhibit A when you're defending your decisions, your ERISA fiduciary decisions, is to show that the committee, the fiduciaries, did their homework and what were they considering, and having that documented to support what you're doing, to show that you did your due diligence and that the fiduciaries were prudent. It's not an ERISA violation to pick perhaps a record keeper that didn't work out. It's at the time you made the decision, was the decision reasonable based on the facts and circumstances and prudent? So I always say I agree 100% that this process has to be documented. And I think also an RFP are useful. It's not just the fees. It's, you don't know what services you're not receiving unless you do an RFP.
That's right.
So if you've had the same record keeper for a prolonged period of time, a plan sponsor might not be aware of the other services and options that are available out in the market, because all they know is their current record keeper. So it's a very healthy exercise to do the RFP.
Yeah, and I'd add to that, we often get time, especially at the beginning of a new relationship. It's not uncommon. The benefits manager will say to us, well, who's the best record keeper out there, Nichole? Like, who should we be talking to? And I always say there's really not a best, right? There are firms that have strengths in areas where your program may have weaknesses. So for that reason, you would want to include them in a search. If, for example, compliance is the thing you're struggling with, there's certain firms that really excel at compliance. If, let's say, you have 20 locations across the US and it's hard to get to those locations and do employee education, and that's a weakness, there are certain firms that do a better job of educating participants. And so that would become a higher priority. So there really is no best firm. It really is firms that have strengths in areas where your program may have weaknesses. And I think that's an important point for plan sponsors to understand.
Well, no, Nichole, thank you so much for this conversation. And I think it's really helpful information for the listeners. This will wrap up our discussion on the consolidation and trends in the record keeper industry. If listeners have any questions or suggestions for future episodes of this podcast, please contact me. You can also visit our employee benefits page at williamsmullen.com/employee benefits. There you can find out more about our team, as well as past episodes of this podcast and legal alerts. Thanks for listening.